Top 5 challenges of visa applicants when it comes to dual intent. Visa applicants have highlighted several problems concerning dual intent when applying for Canadian visas, which stem from the complexities of the immigration process and the subjective interpretation of applications. Here are the top 5 challenges. Number 1. Misunderstanding of dual intent. Many people face challenges due to a lack of clear understanding of what dual intent entails, both among applicants and immigration officers. Applicants often do not realize that expressing a desire to stay permanently can affect their temporary visa applications unless they convincingly demonstrate that they will leave Canada if the permanent resident application is unsuccessful. Number 2. Consistency in decision making. There is often a perceived lack of consistency in how immigration officers assess dual intent across different cases and visa offices. What might be acceptable in one application might lead to refusal in another, leading to confusion and frustration among applicants about how to declare and justify their dual intent properly. Number 3. Fear of visa rejection. The risk of visa rejection looms largely for many as they worry that disclosing a future intent to apply for permanent residence might lead to denial of their temporary visas. This fear can lead applicants to withhold information, which, if later discovered, can be deemed misrepresentation, further complicating their immigration status. Number 4. Documentation and evidence requirements. Providing sufficient evidence to support the legitimacy of both the temporary stay and the intent to apply for permanent residency can be challenging. Applicants often struggle with what evidence is convincing enough to demonstrate ties to their home country while simultaneously planning for a potential permanent move to Canada. Number 5. Impact on family members. Dual intent issues can also significantly impact family members, especially when one family member is applying for permanent residence and the others are applying for temporary status. The interconnected nature of these applications can complicate the approval process, as the intention of one family member might affect the entire family's applications. If you're struggling with the dual intent issue in your applications, you should consult an experienced Canadian immigration lawyer. Click the link below to book your 1-hour strategy meeting with our lawyers.